I bet you'll be just amazed to hear that sometimes retailers try to trick you. So in this video, I'm going through 10 different ways that I come across frequently that retailers and traders try to trick you, some more so than others, and in some industries more than others. And hopefully you can spot these so you won't be caught out next time. So welcome back, but if you are new to my channel, I'm a barrister who helps you understand law, and I've been doing that practically every day now for well over a couple of years. So make sure you hit that subscribe button and the bell icon and like this video at some point if you find it useful. So in no particular order, the first way that some traders and retailers try to trick you is when they talk about the 30-day period, which is a short-term right to reject under the Consumer Rights Act. Now, just as a caveat to all of this, I am talking about consumers, particularly in this video, although some of them can apply very broadly to traders, i.e. people in business, but broadly I'm speaking about consumers. So this 30-day right to reject, it is a short-term right to reject for any reasons that are contained within the Consumer Rights Act. So to make sure that this all makes sense, first of all, there are certain implied terms within the Consumer Rights Act. These are implied regardless of whether the trader likes it or agrees with it or not. Certain terms are implied into the contract, therefore you have this protection within the Consumer Rights Act. One of which is that it's got to be of satisfactory quality. Now that's a question of fact and that will be determined by the court. But there is also a fitness for purpose test, so it must be fit for particular purpose. And so if you make known to the retailer that this is what it's for, it must be fit for that purpose, even if it's not normally used for that purpose. For example, if you were to go and buy some shears which are normally used for cutting hedges, but actually you say you want to cut the lawn with it, and they say, well, yes, of course it will cut the lawn, but if it turns out that it doesn't do that very well, then it's not fit for purpose because that's the purpose that you made known to the trader that you wanted it for. There are also various other implied terms within the Act. I will link the Act, if I remember to do so, in the description below, but I've done many videos on talking about what these rights are. So that just so that this makes sense, if your product or whatever it is that you've bought doesn't conform to the contract with these implied terms by the Consumer Rights Act for any one of reasons whatsoever, you have a short-term right to reject. Now, the important distinction with this is that it is a right to reject. It's not just some term that's within the legislation that means it comes up as a debate and a discussion between you and the trader or the retailer, whether or not you should be returning it, whether you can return it, whether it is or isn't defective in one way or another. You have a right to reject it. Now, this right under Section 20 of the Consumer Rights Act is exercised if you, the consumer, indicates to the trader that you are rejecting the goods and treating the contract as being at an end. In other words, you walk in, you say, this is rubbish, it's not satisfactory quality, it's not fit for purpose, or one of the other things. I'm giving it back to you, the contract's at an end, give me my money back. Now, many traders and retailers, not all of them, some of them are quite good, but some of them will treat this 30-day period as just a period that you can go in and have this chat and discussion about. That's not how it works. As in Section 20, an indication might be something the consumer says or does, but it must be clear enough to be understood by the trader. Now, walking in and saying, this is rubbish, I want my money back, is as clear as it gets. Now, from the time that that right is exercised by saying, this is rubbish, give me my money back, the trader has a duty to give the consumer a refund, subject to various other sections, and the consumer has a duty to make the goods available. Now, as indicated by subsection 18, there are certain instances where there is no entitlement to a refund, but very broadly speaking, if we are talking about a defective product for one reason or another, but this particular section is really talking about whether or not you've paid or transferred something under the contract in order to receive those goods. So we're talking about a simple scenario where it is a defective product or not fit for purpose, or potentially it's just not as described. If it's supposed to be blue and it comes and it's red, then clearly it's not as described. It's a completely different color. Now, just as an aside, I've had one very odd case that actually went to court in this regard, in that there was a very subtle distinction in the colouring of a natural stone. The defendant's perspective was that natural stones vary in colour. My personal view is that the colour varied so much, it was from a sort of silver to a pink or the other way around. My view is that that was a significant difference and should have met the not as described portion of this act for the purposes of the claim. Nonetheless, the court didn't agree. The court took the view that it was a natural stone and accepted the defendant's arguments that that could vary in colour. But I digress. And if I may interrupt the flow just for one moment, if you find any of this useful or you know someone that will, please do bop that like button and subscribe and send this video to them, and I'll be very grateful. Back to the video. So just remember, with regard to this short-term right to reject, it is a right to reject because of one of those points, and then the trader is under a duty to refund you. It is not just a window of opportunity to have a debate with the shopkeeper as to whether or not it should be returned. And just as another aside to this very first point, this is not to be confused with the first 14 days when you buy something online. If you buy something online and you've not had the opportunity to inspect the goods beforehand, you have this 14-day effectively cooling off period within which you can just send it back for no reason whatsoever. That differs from just returning something because you don't like it to a store. You don't have 14 days or 30 days to return something to a store just because you don't like it. The shop is within its right to refuse a refund or an exchange or whatever in those circumstances. But as I say, most shops are quite good at this. They will give you some window of opportunity to return it, even if it's for a credit voucher of some sort or another. But changing your mind doesn't cut it. It has to be a right to reject because of one of the reasons in the act, such as not fit for purpose, not satisfactory quality, not as described, and a few others in the act. Moving on, let's say you've got something and there is a problem with it and you agree to a repair. Now, this throws up a couple of things because you can accept a repair within the first 30 days, even though you have the short-term right to reject. In fact, you have a right to a repair or replacement under Section 23 of the Consumer Rights Act. But as I say, let's not confuse this with the first 30 days to begin with. There is something about the first 6 months, which is that within the first 6 months, if there's a defect, it's taken to be there at the outset, and the burden shifts to you to prove that it was there at the outset or that there was a manufacturing fault after that 6-month period. But speaking about repairs and why potentially some traders might try to trick you, this has been particularly prevalent with car traders and dealers and that sort of thing. Because very often there'll be a problem with a vehicle that you've purchased. Now remember, even if it's a second-hand vehicle, whilst you can't expect it to be absolutely scratch and defect free, it should still be satisfactory quality, fit for purpose, as described, and so on. The as described bit, let's say they tell you that there's a big scratch down the side, you can't then come back and then say, well, I want this repaired, because they told you about it in the first place. If, however, there's a big dent under the bonnet somewhere or somewhere that you can't see and it's not pointed out to you and it's not made clear to you, then you can go back and ask for this to be repaired. Now, here's the trick. Many of them will take longer than the initial 30 days to do the repair. Meaning when you go back, the trick is as follows. They might tell you, well, we've done the repair now. You might say, I don't agree, it's not fully repaired. Then they say, well, it's too late. You're outside of the first 30 days. Therefore, you can no longer reject the vehicle. But the important legal thing to understand here is the law is not on their side. Because if you accept a repair, then this initial 30-day period is put on hold for the duration of the waiting period whilst you are waiting for this to be repaired. So if they take 3 months to come back to you, which, by the way, would be really too long because it's got to be without major inconvenience to you, but let's say you were happy to wait 3 months and you did so, they then come back and say, well, we're well outside of the first 30 days, now you can no longer reject the vehicle. That's not true, because the first 30 days has been put on hold for the waiting period whilst you're waiting for them to get this repair sorted out. So in effect, when you pick it up 3 months later and it's still faulty, you can still go back and say, well, we are now on day 26 because that's the day that I brought it in initially. I've still got a few more days to reject this vehicle and I hereby reject it. Give me my money back. And at that point, they're under a duty to refund you, as they would be in the first 30 days in the first instance. So that's the second way that some retailers and some dealers and so on might try to manipulate the situation. Moving on to the third trick is sticking with repairs, because some traders and retailers and so on will insist that they can attempt repairs as many times as they need to, because they don't have a duty to replace it, they can just repair it. But that's also not true either, because after one opportunity to repair, if it still does not conform to the contract, you have a final right to reject. And the same is true, by the way, for a replacement. Under Section 24 of the Consumer Rights Act, the right to a price reduction or the right to finally reject the goods means that if after one repair or replacement attempt the goods still do not conform to the contract, this is under subsection 5, then the consumer has a right either to a price reduction or the final right to reject. Not both, obviously, because you can't reject it and get a price reduction, because that obviously doesn't work. But you have the right to ask for a price reduction and say, well, you failed to repair it, I'll just take a few £100 off it and I'll keep it. Or no, you haven't repaired it, it still doesn't conform to the contract,
I want my money back.
Don't let traders be telling you that they are allowed to just attempt repairs as many times as possible. That's not the case. You have further protection after they've attempted one repair or replacement. The fourth trick is to do with this 6 months, which I referred to earlier. Now, 6 months is not a limit in the sense that some retailers have tried to say so. Some retailers use this 6-month period within which it is deemed to be defective at the outset if it's found within the first 6 months. Therefore, some retailers and even some finance companies have said that you're outside of this first 6 months, therefore you're outside of this remit for repair, replacement, and you're outside of the Section 75 claim, which I've dealt with in other videos. Very broadly speaking, that means if it's under finance, you have a like claim against the finance company as you do the trader under Section 75 of the Consumer Credit Act 1974. So remember, this 6 months is not a limit for the claim. Simple contracts, the limitation period for England and Wales is 6 years, not 6 months. Although if you do come 5 years down the line and it's something that's only really supposed to last a year or two, you might struggle. But that's the overall time frame. If you can convince a court and get a court to accept your arguments within that 6 years, regardless under the Consumer Rights Act, then that is the time limit. It's not 6 months as some traders would like you to think. The fifth trick I've already spoiled, I suppose, because even finance companies use these time frames as a way to try to stump your claim before it actually gets anywhere. Some of these companies will tell you that you're outside of the first 30 days and you're outside of the first 6 months. Therefore, unfortunately, there's nothing we can do. You, as a consumer, with all respect to you, may just believe that that's the case and there's nothing you can do, never mind, and go on about your business with this broken whatever it is just because it's a bit older than 6 months, but it's actually no good. We've come across some cases that are a couple of years down the line and they are really in bad shape and really shouldn't have fallen apart after 2 years, only 2 years, and therefore there is a like claim because it was still financed against the finance company under Section 75 and against the trader. All under the Consumer Rights Act and all within 6 years, not 6 months. And a similar argument can be made for warranties and guarantees. Now, a warranty and a guarantee are very broadly in nature the same thing. I'm not going to get bogged down in the very subtle distinctions between the two of them. All they are really is a promise to you as a consumer by the trader or whoever it is that's providing the warranty or the guarantee that they will either repair it or replace it or swap parts with it or whatever it is they need to do with it to keep it running and keep it working, keep it going, and to guarantee a lifetime span or whatever it is. Now, also, this can be used as a bit of a trick. So this is my number 6. So some retailers, some traders will say that you're outside of warranty, therefore nothing we can do. Now, let's say this was a 2-year warranty or even a 1-year warranty, and then say, well, it's out of the first 12-month warranty, therefore nothing we can do. That's not strictly true either, because as I said earlier, there is a 6-year time limit to bring a claim in contract for something that doesn't conform to the contract under the Consumer Rights Act. So again, out of warranty doesn't mean you can't make a claim. It just means the warranty, the promise that they made on whatever terms it was, has run out. It doesn't mean you can't claim. The 7th trick is when some traders, some retailers tell you that there are no returns.
No refunds.
Because in some situations, this is very strictly illegal. Now, in one very narrow sense, if you buy something from a shop in person, they can say no returns other than exchange for a credit voucher just because you've changed your mind, because that's fine. As I said earlier, this needs to be contrasted with the first 30 days short-term right to reject and then the right to repair or replacement, because if you just changed your mind and you don't like it, that doesn't mean it doesn't conform to the contract. Because, as I said, it's got to be a breach of one of those terms. Satisfactory quality, not fit for purpose, not as described, doesn't match a sample, and things of that nature. If you just don't like it, you've changed your mind, but you bought it in person, then yes, the no returns thing in that narrow situation is correct. But a blanket no returns policy is almost always going to be illegal, because they cannot say no returns, because that would detract from your statutory rights in the event that it's defective. And if it's defective, you can return it. So most shops, in fact, don't use this no returns label anymore. They have a more detailed policy, but some probably smaller retailers, even perhaps one of the two of the bigger ones, but some of them might still try to sell you the idea of no returns. But this, as I say, if it pops up in that fashion, is a bit of a trick. So watch out for that one as well. Moving neatly on to number 8, this is where they say no returns because you've opened it. Now, subject to some limitations, such as food and health and hygiene type products, and some that you can probably imagine wouldn't want to be returned and resold to another customer. If it's just because you've opened it and it doesn't fit in with one of those exceptions that I've mentioned, then that without more doesn't mean you can't return it. So for example, if I were to open a product and discover that it's broken, the retailer, the trader cannot just say, well, you've opened it, so you can't return it. Because then, quite obviously, I would say, well, it's broken, it doesn't work, it's defective, it doesn't match the description, it's not as fit for purpose, or whatever. They can't just say that I've opened it and therefore I can't return it. The same goes for it must be in its original packaging and packaged in exactly the same way. That's not really true either. There is nothing in the Consumer Rights Act that says you must return it in its original packaging. The only thing it says in terms of the right to reject under Section 20 is that from the time you exercise the right, they've got a duty to give you the refund, and you've got a duty to make sure the goods are available for collection by the trader, or if there's an agreement for the consumer to return the rejected goods, for you to return it as agreed. So again, as I said, if it's not one of those exceptions, just because you've opened it doesn't mean you can't return it. Now, talking about the return itself and the refund itself, some traders still insist that they can only refund you by check. I've talked about this before, where some retailers will insist that they can only refund you by check. That's not true either, because under Section 20, subsection 16 of the Consumer Rights Act, if you, the consumer, has paid money under the contract, the trader must give the refund using the same means of payment used unless the consumer expressly agrees otherwise. And as an aside, the trader cannot impose any fees upon you in respect to the refund either. And finally, number 10, when you are returning something, some retailers will insist that you have to pay the return shipping. Now, there's only a narrow exception when this applies, and that is if you've bought it online, you've just changed your mind, and they've made it clear to you that you have to pay for the return shipping, and that they won't refund you the initial shipping and things like that. If they haven't made that clear, then they need to bear the burden of the cost of returning the goods back. But most of them do make it clear that if you're just returning it because you've just changed your mind, then you have to pay for the shipping. But remember also that if it is a defective product, if you're exercising your right to reject the goods, then the Act provides that to the extent that you, the consumer, has paid money under the contract, you are entitled to receive back the same amount of money. Now, if you've paid shipping under that contract, then you are entitled to receive that back also if the goods do not conform to the contract because of one of these implied terms. So there, as I said, are just some of the common tricks that some traders use to try to prevent you from making a claim, try to prevent you from returning goods, and in some cases just trying to get away with selling something which is substandard, defective, and otherwise just wrong. But as I say, these days many more retailers are cooperating with the law. They are not trying to use these tricks, but even to this day it might just be because some traders don't understand these rules and these requirements within the Consumer Rights Act. It's a very lengthy act, it's very detailed, there's lots of different bits that interact with each other, and quite frankly, unless you are used to reading law and understanding law, you might find it difficult to navigate. But it is an act which is designed to protect the consumer primarily, because ultimately, if these things do go to court, it is really there for the court to use to decide the claim. And it's all drafted up to be fair and to protect the consumer. So I hope any one of those you find useful, you found interesting. Perhaps you found yourself in that situation, or you might through this coming holiday period. If you do, if you appreciate this, please do like this video and remember to subscribe. And as always, thank you so much for watching.